in this session, we are going to discuss the national reports, and in particular, we will focus on normative, constitutional, legislative framework on participatory democracy, with reference to the combination of representative, direct, and participatory tools to ensure participation of the public. In this report, it was also analyzed the role of constitutional oversight institutions, namely those institutions who are in charge to ensure that people have access to participatory, can exercise their participatory right. And then we have analyzed vulnerable groups, and in particular the barriers that these groups can face in having access to their participatory right. Finally, we have concluded that our constitutional experts have explored from a wider perspective the constitutional culture of each national experience, the public trust in institutions, political discourse and media, the role of NGOs, and the compliance with constitutional standards, as well as with European and international standards on democracy. Finally, in this report, we have tried, and our experts have tried to highlight main strengths and weaknesses of each national system to ensure public participation. So I immediately give the floor to our speaker, our first speaker, Professor Motra. Good afternoon. Thank you for being with us. Professor Motra is Professor of International and EU Law. She is also Dean of the Faculty of Social and Economic Sciences at Community University. And her research and publication focus on different aspects of human rights. Please go for it. Of human rights, both at the international and EU level. She's expert on EU institutions and EU law implementation, and she is also a great expert of EU foreign policy with reference also to human rights protection in the enlargement process. So thank you once again for being with us. The floor is yours.
Thank you very much, and thank you for the organizers and professor for organizing the meeting, the forum, and also for the very nice environment here at the University of Milan. So I will present part of the national report from Slovakia. Also, the time is limited, so not every detail. But as you mentioned, I will focus on the tools which are existing. The normative framework will be mentioned mainly in the written report, so I'll try to give you the examples from the practice, how these tools had been operationalized, how they are working or not working in the practice, and what are the main, or where the main challenges which required, for example, the interpretation by the Constitutional Court to ensure that these tools are fully applicable in the practice. So the presentation is divided to two parts: civic engagement and then the political participation. The very first one, civic engagement, will be very short, yeah, and that's only one slide over there because there is no central citizen engagement online platform, and there is no specific tool for the citizens engagement in general in Slovakia. So what we do have very recently is under the specific politics and policies. For example, in the environmental policies, there are obligatory consultations and obligatory hearings, but this is not obligatory in any other areas in these regards. And with that, I can show you the one concrete example where the civic engagement was very recently, literally in May or between May and June this year, organized in Slovakia in a way to establish the wind plants in Slovakia as their quite common alternative renewable resources. There was launched within the environmental impact assessment public consultations, which involved the different stakeholders, the ministry, the people from the parliament, the governmental experts, and the environmental agency. This consultation was held or organized with the citizens general population and those who are actually living in the area where the plans are supposed to be constructed. For the first big challenge, it was that the room for the consultation was limited to 500 people. So it was literally in one theater over there. There had been much more people standing outside without any access to the consultation itself. The consultation was held in person. So those who didn't make it to the room have not been heard. The second thing was after 1 hour, it became not the engagement, but the fighting arena. So after 1 hour, it had to be the police called, and the whole meeting was dissolved, with some people taking even into the custody and investigation because they started to fight. You know, those who had been in favor and those who had been against. So it was much more not a consultation, but in like the attack of two opposing parts. So the public hearings in these regards are not actually happening for the moment. And if that happens, this is the example how it works in the very recent practice itself. But we do have the alternative tools, which I will mention throughout the consultations and the participation itself. So in the second part, I will much more focus on the public participations, petitions, referenda, consultations, and then the political rights. A bit of the framework, as you can see, and as you can also find out in the report, we do have functional rights to petition, which is understood to be available on all levels, the national, regional, and even the municipal level in these regards. And there are specific requirements for the petition itself. So it means that there are, for example, the number of people who had to ask and sign the petition. We do have a petition calling also for the national referenda, where it is required the signatures of 350,000 people to sign. And that one was, as you can see, based on the law, which was actually adopted in the time of Czechoslovakia. So we just follow and amended this law a bit. But the very recent amendment was based on the finding from the Constitutional Court, because the part of the petition is that everyone has to provide their personal data. And the law from 1990 didn't reflect the requirements of the personal data protection as required by the GDPR and the national law on the personal data protection. So the amendment just provides that for the purpose of the petition, the subject which initiated the petition and register the petition with the Ministry of Interior can operate with the personal data as the first name, last name, permanent address, and date of birth and signature, in a way to verify that there is a sufficient number of signatures to run the petition based on this. Then another tool which is complementing the petitions in a way to have the access to concrete information, and it is to some extent considered as a right to petition, is the individual petition. And this individual petition is as a tool of monitor and control the public authorities. And for that purpose, we have in Slovakia the law which provides the access to the information and the protection of people who require this access, the protection of the whistleblowers itself. Even with that legal protection, there was established a specific national authority for the protection of the whistleblowers to provide the sufficient protection, but also to proceed and control the national authorities in these regards. And you may heard or may read about this. This was literally under the attack since last year when the government proposed the amendment to the law, which passed in the national parliament, which suggested dissolution of the office for the whistleblowers and weakening the protection of people's right for the petition and people's right for the information under this specific legislation. I said that you may heard about it because this was also the concern of the European Commission, which initiated the infringement or the first steps for the infringement procedures, because that amendment was not compliant with the directive on the whistleblowers protection. And with that initiative of the infringement, the parliament changed the legislation within the consultation process with the European Commission. However, you still can find the notice of this attempt to breach the rule of law and the protection of the right to petition under the Slovakia National Rule of Law Report for 2020-25, which was published just in June this year. Another example, very recent, it may seems that everything literally happened in the last 6 months. We had the right to referendum, which is constitutionally provided, and then we have a specific law for the procedure of conducting the referendum. This requires or establishes the possibility of asking even, like the Constitutional Court for the constitutional review ex ante, whether the question which will be set in the referenda are constitutionally compliant. So literally to prevent any public finances waste, or asking the question which is not compliant to the Constitution and our international obligations. We have had in Slovakia, and if I'm counting correctly, since last Saturday, 13 referenda, out of which only one had been successful. This one was connected with the Slovak membership to the European Union and held place in 2003. The success referendum requires in Slovakia that more than half, 50% of people who has a right to vote are participating in the referenda. So when we are talking about 5.5 million Slovakia, that means that more than or around 2 million are entitled to vote. So it means at least 1 million something had to be participated in the referenda, which occurred only once. The very last referendum had happened on 4th July. Which was actually initiated based on the petition of 400,000 citizens to call for to some extent call for the review or termination of the law which proposed the lifelong rent for the prime minister when they finish the office and serving as a public servant itself. That kind of a rent we do have for former presidents or the former chairs of the Constitutional Court. We do not have it in the moment for the prime ministers or any other constitutional position itself. So this was called in the referenda by the petition. The referenda was unsuccessful with a 16% only participated in. And there had been a big discussion in the last week about the efficiency of public spendings, because the referenda was or the expenses was around 10 million euro for this, which is like a huge amount, as we heard in the morning session as well. The Constitutional Court in this regard several times also reviewed the questions which were proposed in the referenda itself within this constitutional review. And there are two main messages coming from the Constitutional Court per se in general. The Constitutional Court is not obligatory consulted for the questions in the referenda. It's the discretion of the president to ask the Constitutional Court whether the questions in the referenda are constitutionally compliant or not. So we did see a couple of times that depending on the concrete personality, the president asked. But for example, in the last referenda, the president didn't ask about the questions and decided to strike out the fourth question and run the referenda only with 3 of them, based on the opinion of the experts he has in the house in the office of the president. So only the Constitutional Court served and clarified that the response can be held if the president is asking, and it has to be in between the petition is delivered and the referendum is held. So only ex ante. Yeah? And then the Constitutional Court itself provided a second interpretation in 2022, that it doesn't have the right to interpret the results of the referenda, but only can provide like the review, constitutional review of the process. So it means whether everyone was acting in a way as the discretion and the separation of powers is implemented in the practice. Another tool which exists in Slovakia are public consultations. As I already mentioned, it is to some extent complementing the lack of public consultations or public hearings as a tool of civic engagements. The consultations are mainly exercised in a general way as a public consultation to the draft of legislations. Sometimes the government or respective ministry is running also consultation to political strategies, especially if we are talking about the long-term strategies like strategies of the Roma inclusion for 10 years or the housing strategy for 10 years or any other long-term strategies itself. But that one is voluntary. The obligatory consultation is running to the draft of all legislation. This is held through the specific portal, which is called Slovlex, which is like Slovak legislation, where the draft legislation has to be published, and anyone can, through the portal, submit their views, their comments, and this is the way how the consultation is run. There exists one specific tool, which is called like a mass command mechanism. If there is more than 50 subjects, either individual or institutional, they can submit like a common or mass command, which means that in that time, the drafter of the legislation is obliged to consult with them the content of the comment itself. So it means that there has to be a meeting to discuss the content of the consultation of the comment itself. In practice, it's usually run in a very closed session, where there are at maximum 2 or 3 persons from the commentary sides, and the whole bench of the representative from the ministries and mainly the lawyers. And I do not have a specific statistics, but the last ones I just counted from 2026. Literally less than 10% have been taken on board. So from the mass comments. So it's not very effective, although it is in the place. Couple of very interesting or curious comments in this system, which is very specific for the Slovak legislation. We do have in this commenting or public consultation for the draft legislation obligatory subjects which had to be consulted, and one of them is the Conference of Bishops of Slovakia. So also we are not a clerical state. Slovakia has the bilateral agreement with the Holy See, which requires that they are obligatory consulted in these regards. And they have the right to provide their comments. Their comments had been not like regular ones. They provided substantial comments in the last drafts or the amendments to the law on education, especially regarding the content and extent of sex education in the curricula in primary and high schools, or on the school reform in these regards, which presented that if the school is already financed by the church, it should not receive the money from the public budget, because the church already received the money from the public budget, so it will be double financing. So they commented that kind of draft legislation. And then, of course, again, connected with the education, there is a possibility in Slovak primary and high school to decide whether the children is taking the civics education or the religious, and that are equal in these regards. So they commented on the requirement to have more hours of the religion in this draft legislation. So that's just out of curiosity to see who is obligatory comment. There is a specific role played by the number of the government advisory bodies in the consultations which are connected or topic focused. For example, the Economic Council is obligatory consulted due to economic impacts itself. Also, the parliament has to do the economic and fiscal impact assessment to each draft of the legislation. But then, for example, for the innovations or the research and development or the drafts of the legislation which are connected to the human rights, there are specific advisory bodies to provide the comments, also not very much often used in a practice itself, but normative framework is perfect on the paper. The implementation practice is different. This bit varies or differs from the local and regional level, where it is working much more effectively. We do have a very effective system of the digital participation on the local level, on the level of the capitals of the regions. So not small authorities or small municipalities, but the big ones. There exists a system of participatory budgetings, where there citizens of the city or the region do have up to 10% of the budget to decide about the concrete focus of the spendings. Or there are specific reporting tools, which is called like a odkaz pre starostu, means like the message for the mayor. So anyone can provide their concerns, and then they are publicly responding or acting in these regards. The way of responding is up to the concrete mayor in this way. These two are mainly very positively understood by the citizens. And with every local elections, there is the attempt to increase their using in the practice itself. And I don't know that I don't have so much time, so I'll try to give a bit of an overview of the other rights which are allowing the public participation, highlighting something which is very specific for Slovakia in regarding to voting rights, freedom of speech, freedom of assembly, and freedom of associations. In relation to the voting rights, we have had a long-standing electoral rights coming from the Czechoslovakia times, and only in 2014 we get the new law, one unified law, where all the elections are regulated. So municipal, local, regional, national parliament, European elections, all in one legislation itself. This law also goes a little bit beyond, because it provides also the specific part or specific chapter on the finances to political parties, because the political parties in Slovakia are financed from the state budget. So if they made the threshold of minimum 3% in the national elections, they do receive the finances for the term for 4 years from the state budget itself. Also, the threshold for getting to the parliament is 5%. 3% is enough for financing from the state budget itself. There is also the campaign, the whole chapter on the campaigns, and establishing the financial caution to the elections to the national parliament and the European Parliament. So political parties which would like to propose their nominations to these elections have to provide the caution, which is 25 times of the minimum wage, which is around 1,000 euro, as a caution to participate in the elections. If they do not make this 3% in the elections, the caution is getting to the state budget. If they made it, they receive it back, and also with the finances for the next 4 or 5 years. There comes also one very specific 2 points which ran literally this year. There was the draft, or there is a draft on the abolishment of the elections by the post. Slovakia do not have digitalized the electoral system, so there is no possibility to vote electronically. And we do have only for the national parliament the vote by posting. The current government proposed the legislation, which is right now in the second hearing, in the second reading, abolishing this possibility of voting by post, which will limit the right of the diaspora in these regards to participate in the elections, and it is pretty much criticized by the different stakeholders. Another important point: up to 10 years ago, the rights of a specific groups. Also, let's say not vulnerable groups per se, had been limited in elections. For example, up to 2015, when the Constitutional Court decided prisoners didn't have a right to vote, neither to spend in the elections, because there was no the electoral district for the prisons. So in 2014, there was, like the claim to the petition to the Constitutional Court, and the court decided that in general, restricting the rights of the prisoners to participate in the elections is unconstitutional and is contradicting the European Convention on Human Rights. So the prisoners are also eligible to vote. On this regard, unless there is like health protection or infectious disease itself. In this regard, to some extent, without the specific interpretation, the municipalities are running also specific districts, not only in the prisons, but also in the hospitals. So the people in the hospitals and the care houses are also entitled to vote. Then also there had been the findings from the Constitutional Court that people with disabilities, for example, intellectual disabilities, mental conditions, had been in general like excluded if they had been in like terminated their legal capacity. The Constitutional Court in 2016 ruled that there cannot be like the general approach. Each case has to be assessed individually and pending also from elections to elections. So if there is a limited legal capacity in one elections, doesn't mean automatically in general population that they are disabled, because it would be from the elections, it will be contradicting the CRPD itself. And then one last from a very recent 24th of June, if we are talking about the non-discrimination in elections, we have the incoming local and regional elections in October this year, and the Public Defender of Rights asked the Constitutional Court on reviewing the legislation itself, allowing, especially in two big cities, in Bratislava, the capital, and in Košice, to have districts within the city, electoral districts, which have a different size. So it means practically that in one district you require to be elected 1,000 votes, while in another it's 5,000 votes, depending on the size of the district itself. The Constitutional Court ruled that this is like contradicting the right to vote and stand in the elections, and also the International Covenant on Civil and Political Rights, and disobeyed this provision of the legislation, and the law was already amended. For the freedom of expression and the right to information, just one very important point. We do have the access to information specific law. And one more point in relation to the peaceful assembly, we do distinguish between civic assembly and the political assembly. And you may saw in the news the several mass protests in Slovakia exercising the right to assembly. In these regards, there was one particular change in 2025 because of the assassination of the prime minister. They make the rules on where it is not possible to exercise the right to assembly, including like to making the no-flight zones, no drone zones, because as you can see, also this picture comes from the drone itself. So that to some extent rather regulate than limit the exercise of this one. Really last point, we do have, because this one is important, we do have the tool, like civil society organizations are very important in exercising the political participation and allowing the civil engagement. The draft of the legislation in 2022 was following the attempt which had held in Russia, Hungary, Georgia, limits the rights of existence of the NGOs. The law was adopted under the current government, again challenged by the Public Defender of Rights and the MPs, and the Constitutional Court found it unconstitutional. So in this regard, we had been able to stop it due to other functioning mechanisms, which is still like something which is occurring in the other countries, because, for example, the very similar approach, like the Hungary had it, but the similar approach to provide this kind of a draft of amendment is also in Czech Republic under the Babiš government to restrict the civil society organizations. And with that, I will just finish. Thank you for your attention.
It's a really interesting presentation. We move swiftly to our next speaker, my colleague, Dr. Mirko Della Malva from University of Milan, who is going to present the national report on Italy. He was a team member of the already mentioned project of national relevance on participation, inclusion, and rule of law, coordinated by Professor Di Gregorio. He holds PhD in constitutional law. He's research fellow here at the University of Milan, and in his research, he has explored evolution of state and government structure, as well as dynamics of a participatory democracy, nationhood, linguistic minorities, memory laws, and he wrote a really interesting monograph on law and historical memory. So thank you, Dr. Ramalba, for being with us. The floor is yours.
Thank you, Arianna, for giving me the floor. And my task today is to present the Italian case. Before I begin, however, I think it's important to clarify key terms first, because they help us understand our report correctly. The overview brings together all the different forms of participation that exist in the Italian legal system. Yet, in Italian public law, these forms don't belong to a single uniform category, but they are traditionally divided into 4 distinct models, each serving different role in a democratic system. Representative democracy refers to participation through elected bodies such as parliament, regional, and municipal council, where political choices are made by elected representatives. Direct democracy includes mechanisms that allow citizens to take part directly in the law-making process, such as referendum, citizen legislative proposal, and petition. Participatory democracy concerns citizen involvement in administrative decision-making through tools such as public hearing, consultation, participation in administrative procedure, and participatory budgeting. Finally, deliberative democracy covers more recent and experimental processes, in particular citizen assemblies and public debates on major infrastructure projects. It's a system in which a group of citizens discuss public issues in a structured way with the aim of informing the decision of public authorities. These 4 models coexist in Italy, but they are based on a different legal foundation, enjoy different level of constitutional and legislative protection, and produce very different practical outcomes. The distinction is important because it helps us understand how participation is organized in Italy and why different participatory tools function at a different level of the system. With this clarification in mind, we can now turn to the Italian model, which after almost 80 years of development is therefore inevitably complex. The Italian Constitution, as you know, was drafted in 1948 in clear opposition to the fascist experience. The origin is not just an historical detail. It explains why the Constitution is so rich in participatory instrument and individual rights. In fact, the Constituent Assembly wanted to guarantee that citizens would never again be reduced to a passive subject of an authoritarian state. For this reason, it included into the text a broad and systematically interconnected catalogue of participatory rights: universal, equal, free, and secret suffrage under Article 38, freedom of assembly and association under Articles 17 and 18, freedom of expression under Article 21, the right to petition to Parliament under Article 50, the right to access public office on equal terms under Article 51, the popular legislative initiative under Article 71, and finally, the abrogative referendum under Article 75. Alongside the traditional instrument of representative and direct democracy, the Constitution also contains a provision that became particularly important in the life of the system, such as Article 3, Paragraph 2. The article requires the Republic to remove the economic and social obstacles that limit citizen participation in political, economic, and social life. In other words, the Constitution does not focus only on formal equality, but also ensuring that everyone has a real opportunity to participate in the life of the country. However, some of these constitutional principles remain largely on paper for the first 20 years of the Republic history. It was only in the 17th they are started to take concrete legal form. The 17th were in fact the period in which the constitutional framework for participation was first put into effect on wide scale. Law 352 of 1970 regulated the procedure for conducting abrogative referenda, making Article 75 as a real live instrument. On the basis of this new act approved by the Parliament from 1974 to the present, 77 national referendums were held, addressing issues of high political and constitutional sensitivity: divorce, abortion, nuclear energy, public broadcasting, political party finance, the electoral system itself. The referendum became for a generation of Italians the primary mechanism of direct civic engagement with national politics. The same period saw the creation of the ordinary regions, which added a new electoral and participatory level to the institutional system, and also the first experiment with the local assembly and participatory practice on major cities, most notable Bologna. This is a referendum. Later, the 19th brought a new wave of innovation. Participation moved from the political to the administrative sphere. On this point, I need to specify that in Italy, public laws is traditionally divided into constitutional law, which define the structure on the state and the guarantees fundamental rights, and administrative law, which governs how public authorities operate in practice and how citizens can challenge their decision. The pivotal instrument in this fight was the law number 241 of 1990, which established the general framework for administrative procedure and made stakeholder participation a basic principle of public administration. It gave citizens the right to be informed, to express their view, and to access the documents. This was an important step because participation was no longer limited to the ballot box, but became part of every administrative decision-making. This principle was gradually translated into practice across a number of sector-specific law. Environmental law legislation played in particular a lead role by introducing access to information, consultation procedures, public involvement in the waste management planning. Over time, similar participatory measures were also incorporated into public procurement and urban planning regulation. Finally, the 2023 Italian Public Contract Code, drawing inspiration from the French débat public, made public consultation mandatory before the building of major infrastructure projects in the country. From the early 2000s, the Italian system began to introduce new instruments of participatory and deliberative democracy. They arose as a response to the rise of traditional politics party that had opened with the collapse of the so-called First Republic after the Tangentopoli scandals. In this context, the main driver of innovation was not the central state, but once again region, which after the 1999 and 2001 reform of the fifth title of the second part of the Constitution saw their legislative powers significantly extended. This shift increased their institutional role and moved the system towards a more federal model, giving them a greater influence on public policy. In this new wave, Tuscany was the pioneer. Its 2007 law was the first comprehensive regional statute on participation in the country and quickly became a reference model for other regional authorities. It recognizes participation as a right, extend it or resident without any citizen requirement, introduce a mandatory regional public debate for major projects, established an independent regional authority for participation, and finally, and this is a key element, introduce an obligation to public administration to justify any decision which not adopt the outcome of participatory process. This is particularly important because it makes participation a necessary step in the decision-making process, limiting the freedom of administrative action. This law was followed by the legislative initiative of Emilia-Romagna, Puglia, Marche, Umbria, Abruzzo, and Campania, each adopting measures with a different level of ambition. The autonomous province of Bolzano-Bozen instead created a citizen council inspired by Ostbegen model, where randomly selected citizens take part in discussion on public policies. The consequence is a real multi-level system of participation, but unfortunately not uniform. Access to organized participatory process change a lot from one region to another. Someone living in Tuscany benefits, for example, on well-developed set of guarantees, while someone living in a region without a framework law find much more limited tool. In practice, this means that people have different opportunities depending on where they live. As we can see, the Italian participatory framework is formally rich, but this doesn't mean that each form of participation has actually worked as frames had hoped. In our report, we point out, for example, the following main limits. As for representative democracy, voter participation has been declining for many years. Turnout was above 90% until 80s, but today is around 60–65%. This decline doesn't affect everyone in the same way. Young people, low-income citizens, resident in the south, and people who live far from the municipality where they are officially registered vote much less. One reason is that the electoral system is quite inflexible, since people must vote in their municipality or residence rather than where they actually live. In these ways, as you can see, voting became more difficult for many categories of people. In addition, people with disability still face practical obstacles at polling stations, and these despite legal accessibility requirements. And then around 5 million of non-European Union residents are excluded from political voting. These are together. Regarding direct democracy, and in particular abrogative referendum, it's clear that this instrument has gradually lost credibility. The quorum rule, the quorum rule, which require participation from an absolute majority of eligible voters, not just a majority of those who actually vote, has become a mechanism that works against participation. Since the late 19th, reaching the quorum has become the exception in the Italian public framework, and political actors have learned how to use this tool. Instead of convincing people to vote no, they encourage them to not vote at all, counting on the quorum to fail. In practice, abstention ends up having the same legal effect as a negative vote, which is hard to justify from a democratic point of view. The popular legislative initiative faces instead a different but equally structural problem. Parliament is not required to examine or vote bills submitted by the citizen, and many of them simply expire at the end of the tenure. In administrative matters, the main problem that limit participation rights come from Article 21 of the Administrative Procedure Act. This rule allows public administration to keep a decision in place even when participation rights haven't been fully respected. If they can show that citizen involvement would have changed the final outcome, the decision is confirmed. In practice, this is evident, reduce the value of the participation. Administration have a little incentive to follow the procedures because they can still defend their decision. As a result, participation is recognized by law, but its practical impact is often limited. Finally, when we look at participatory and deliberative democracy, the main weakness is the absence of national framework law. Without common standard on inclusiveness, quality, transparency, and follow-up, participatory process risk reproducing the inequalities they are supposed to address. Well-resourced and organized interests tend to dominate consultation, while vulnerable groups deal with informational, economic, linguistic, and cultural barriers to effective engagement. If these are the general consideration, a few specific points need to be underlined when it comes to the participation of vulnerable groups. With regard to linguistic minorities, Article 6 of the Constitution gives them specific protection, but level of safeguard really depend on their history and whether they are located in border region or not. Communities such as the French, German, and Sloven-speaking minorities living along the Italian borders enjoy much stronger protection than groups that are spread across the territory. The most developed model is in Alto Adige-Südtirol. The protection of the German-speaking communities comes not only from the Italian law, but also from the Gasperi-Gruber agreement between Italy and Austria. It's a very strong system, second only the Swedish model for the Finnish minority in the Highland. And it makes political, cultural, and administrative autonomy. One key element is linguistic proportionality. Public administration jobs and positions in local institutions are divided among the German, Italian, and Latvian groups, according with the linguistic declaration made during the census. This means that language protection is closely connected to the real balanced representation in decision-making. For the other historic linguistic minorities instead, such as the Occitan, Catalan, Franco-Provençal, and Arbrecht Albanian communities, Law 482 of 1999 provides cultural rights in the municipality where this group have traditionally lived. These include teaching the minority language in school, bilingual place names, the possibility of using the minority languages in contract with local authorities, and support for cultural activities. These are important measures, but they do not give minorities any specific rights to participate in political or administrative decision-making. By contrast, gypsy groups such as Roma, Sinti, and Caminanti are not recognized as linguistic minorities and remain in condition of marginalization. With regard to women's participation, it's important to underline that their presence in institutions has improved thanks to the constitutional reform of the 2001 and 2003, which made it possible to introduce gender quotas in electoral lists and the double preference mechanism in the vote. Despite this progress, women still make up only about one-third of parliament and less than 15% of majors. In addition, structural barriers, care responsibility, unequal access to resources, and deeply established cultural attitudes continue to limit their effective political involvement. As for transgender people, instead, we can say that voting conditions have improved in recent years. The separate male and female lines at polling stations have been removed and replaced with a single line for all voters. This change reduces visibility and discomfort and makes the voting experience more inclusive, even though some obstacles remain, especially regarding documents and sporadic, more intrusive checks. With regard to non-European Union residents, we should note that these remain a major area of exclusion. Around 5 million people live permanently in Italy, follow its law and contribute to its society, yet have no access to political voting rights. The Constitutional Court confirmed this restriction in 1999, although it left open the possibility for Parliament to extend this right in the future. Some municipalities have created a consultative council for migrants community, but these bodies have unfortunately no binding powers and their practical impact varies a lot. On the basis of this overview, we can conclude that the Italian participatory system has a broad and well-developed normative structure. Its constitutional architecture is generous. The national legislative framework has grown significantly since the 70s, and the region has developed an important innovative models. Finally, constitutional and administrative case law has played a major role, gradually reinforcing individual guarantees and consolidating a favorable approach to participation rights. Nevertheless, this normative richness has not always translated fully into practice. Even today, there are significant gaps between the level of protection formally provided and the actual ability of participatory mechanisms to influence institutional and social reality. Access to participatory tools change across territories, social groups and institutional levels, and the current framework isn't fully able to address this difference. In addition, civil structure future limit the real impact of the participation. These include the referendum quorum, the no-binding nature of popular legislative initiative, the rule contained in Administrative Procedure Act, at last, the absence of the national framework for deliberative democracy. Overcome this gap between constitutional promises and democratic practice is the main challenge for the Italian system will face in the years ahead. Thank you so much for
interesting presentation. We move immediately to our next speaker. Thank you. We probably have a chance to discuss the contents of the report in the following session on the debate. I give the floor to Wojciech Director. If you have a PowerPoint presentation, maybe you can come here closer to the microphone. This is yours.
Thank you.
Thank you. And from the Jagiellonian University in Krakow, who is going to present the national report on Poland. Wojciech Firaki is a PhD candidate in law at the Doctoral School of Social Sciences of the Jagiellonian University, with a research project on citizen participation as a tool for strengthening democracy, supervision of Professor Florczak Bontor. And he's also associate at the Constitutional Law Department and at the Center for Interdisciplinary Constitutional Studies. But he is not really involved in this topic only from theoretical point of view. It's my pleasure to remember that you are also in practice really involved in participatory democracy. He is member of the International Association for Public Participation, IEAP2, and of the International Observatory on Participatory Democracy, OIDP. And but also, probably the most important thing, is also the founder of the association, the Polish Democracy in Practice Association. So thank you for being with us today, and the floor is yours.
Thank you very much for this kind introduce me. Good afternoon, ladies and gentlemen. After this Italian case, I think we can take a short flight to Poland, because I would like to present you briefly, describe the most important points of the report on national case study of Poland that I prepared to this project. I divided this presentation to three main points. First of all, I would like to say a few words about constitutional framework for public participation in Poland. So I think we'll be close to what we heard about Slovakia case and Italy. Then I would like to describe the participatory toolbox, which I understand as a catalog of legally recognized institutions, tools, for public participation, of course, in Poland, in the context of Poland. And finally, I would like to present advantages and challenges for public participation from this perspective. So let's start from our Constitution of 1997. It's worth to note that this Constitution doesn't expresses verbis the term of public participation, citizen participation, or citizen engagement, but I believe that from totally of constitutional provisions and from some principle that our Constitution provides for, which are on the slide, if you can familiar with that, we can assume that there is something like an indirect principle of citizen participation. For instance, Article 1 of our Constitution states that Poland is common good of all citizens. So this means that every citizen is not only the beneficiary of the state, but also should contribute to the state also through public participation, according to the principle of democratic state governed by the rule of law, and also linked with the principle of national sovereignty, which I think is very close to all of our jurisdiction. We may say that in the state governed by the rule of law, the source of the public power is the nation, in political sense, the community of all citizens. So therefore, only the nation may exercise the public power directly through also public participation or by the representatives. Polish Constitution also established principle of pluralistic civil society in Article in combination of Article 11, 12, and 20 with the scope of broad social dialogue. So we can say that public participation is recognized by the Polish Constitution in an indirect way, and as a constitutional value, as also a constitutional principle is provided by the Constitution. To implement this principle, I think that very important is to require healthy democratic environment, let's say, and to ensure that environment, we need to the catalog of human rights and freedoms, which Polish Constitution also established. As you can see, the freedom of speech, freedom of peaceful assembly, freedom of association, right to public information, access to public information, including access to public information like public documents, online or by individual request, and also the participation in the session of Polish Parliament and local councils. Also the electoral rights. When it comes to this point, I need to mention that Polish Constitution provides the free, universal, and direct elections for members of Parliament, the upper Senate, the upper chamber Senate, and the lower chamber, the Polish Sejm, and for the office of the President of the Republic of Poland, as well for the local governmental bodies on each three levels of self-government units. The right to vote is addressed, of course, to Polish citizens, as well on local level, also to European Union citizens. And the right to be elected is also addressed to Polish citizens and depends on the age in specific categories of the election. But in practice, elections, we need to note that is then definitely monopolized by the political parties. However, the citizens also can propose the candidate for some electoral positions. The average voter, because Mirko presented this database, so maybe let's show also some data from Poland. In Poland, the average voter turnout is about 50% in parliamentary election, more like 59% in elections for the office of President of Poland. In local election, about 45. And what is interesting, the highest voter turnout was in the last parliamentary election, 2023. It was reached 74%. Then the Polish Constitution also provides for the right to submit petitions, so pretty similar like a Slovak Constitution, I believe. Also, we have the proposals complaints. It's from our Soviet times, let's say. Protection of gender equality in public, in social, in cultural life, of course. The protection of national and ethnic minorities to develop their own language, own culture. This is the right that Constitution protect, and the right, and the last one, the right to education, including the civil education in Article 70. This is important because I believe that the common heart of this right is to enable the public participation in the public sphere, also in the national level and in the local level, so all levels of governance. Moreover, just to plug it up, the Polish constitution also provides some mechanism to protect these political rights and freedoms. Just to plug it up, we have right to court. When it comes to participation, very important is Anti-SLAPP Act, which is maybe you are familiar. It's the implementation on European Directive on limiting strategic lawsuit against public participation. This month, the Poland's parliament adopted this act, which enables the court to dismiss the case in preliminary stage if the court considers that the case is the strategic lawsuit against public participation, which means that the case is the goal of the case is limited to public debate. Another mechanism to protect these constitutional rights, the right to compensation for illegal actions by the public authorities, right to appeal to the Constitutional Tribunal, so constitutional complaint, of course, and the right to appeal to the Commissioner for Human Rights. That's the constitutional framework for how human rights and freedoms in political sense should be protected. So let me move to the second part of my presentation, to the participatory toolbox. I present this participatory toolbox in two perspectives. First one will be from the constitutional perspective, which is provided by the constitutional provisions, and then I go through the specific provisions from the ordinary acts. The Polish constitution established some participatory tools, which are traditionally, I believe, classified as direct democracy forms, which is quite interesting because the constitution is linked with the direct democracy forms. Of course, from also the Article 4, we have two forms, like a representative and direct form of democracy. However, the ordinary laws go step forward with some institutions from participatory democracy and from the deliberative democracy. So when it comes to the constitutions, the first one is the citizens' initiative, legislative initiative. At the national level, to initiate the bill, the citizens should form the committee, draft the bill, and then collect at least hundreds of thousands signatures from the people who support the bill. The Polish model of citizens' initiative is formulated because citizens should prepare already bill that should be suitable for the adoption, and of course not binding for the parliament, because parliament may accept it, may reject it, and also may make some changes in the bill. Moreover, what is unfortunately there is no legal deadline for the parliament to receive to review the bill. So many of the proposals are expired until the statute of limitations is there, because in that case the statute of limitation is just 2 terms of parliament. In practice, I know that in this term we have 8 parliamentary bills which are proposed by the citizens. 2 are adopted, then the rest are waiting for the working in the commission. But in general, in practice, the literature said that this institution is really rare in Poland. It's estimated that's around 1% of all legislation. So also the literature highlight that the process of collecting this huge number of signatures is also difficult for the citizens. What is interesting, maybe the right to initiate local laws is also applied in the local level and depends on the size of the self-government unit. The second constitutional tool of direct democracy is the right to petition, as I mentioned before. A petition may concern a request to amend the law, to issue the public decision, or take the action by the authorities. Of course, authorities are not obliged to implement the subject of the petition, but they must to reply and to start, let's say, from participatory experience, something like a dialogue between the public authorities and the citizen. What is different than Slovak case, if I'm correct, the petition in Polish case may be submitted by individual person or also the group. So it's the same, right? In the group. Okay. So we have the individual petition and also should be. So Constitution doesn't say this regulation. So could be proposal just by the individual person or just by the group. Third participatory tool that provides Constitution provides is the referendum. We have 4 categories of the referendum. First one is regarding the matters of particular importance to the state, which can be called by the public authorities or also by directly by the group of at least 500,000 citizens, so very, very huge number. The second one is regarding the ratification of international agreements transferring the powers to international organization. And the last one is about approval of the constitutional amendment. For the results of these 2 referendum, the binding to be binding, the voting turnout must be at least 15% of all citizens who have the right to take part in the referendum, except for the constitutional referendum where the turnout is not binding. Unfortunately, in practice, referendum are relatively rare in Poland too. At the national level, only 6 in our history from 1997 referendums have been held, except referendum on amending the constitution, which has never been conducted. Pretty similar on local level, members of self-governing community may also decide in referendum on matters concerning their local community. And once more, including also the recall referendum of public authority comes from the local elections. On national level, there isn't any recall referendum. General experience shows that local referendum are also rare. But however, I need to add at this moment that I'm from Krakow, and maybe 3 months ago we had a recall referendum and we removed our mayor from this position. So it's also working. Last but not least, the Constitution also established citizen participation in the judiciary as the institution of lay judge. In practice, the participation of lay judge in Polish system is not extensive and limited to certain cases, particularly the criminal cases. When it comes to the other participatory tools provided by the ordinary laws, when I said before, it's more linked, I think, with the direct and participatory democracy and also with the deliberative democracy. The most popular form of such institution is for sure public consultations. The legal basis for the public consultation can be found in various legal acts. Consultation may be optional when they are conducted on a general competency standard, or mandatory when the specific provisions requires them to be conducted. And then when the consultation are not conducted, this means that we have the violation of the law, which are the subject of the revision of administrative court. The law doesn't specify the methods of public consultation, so it can take from different types, like a survey, opening meeting, calls, or online forum. Here you can find some the most popular consultation in Poland about public consultation on bills in the same. So it's the consultation in the lawmaking process before the first hearing in the Polish Parliament, public consultation on government's documents, also in the lawmaking process when it comes to the governmental documents, and local consultation on important matters refers to the local community. The next tool is public hearing, which is also which could be part of the lawmaking process. The legal basis for the public hearing is in Lobbying Act and the rules of procedure of Sejm and Senate. The purpose of public hearing is to allow all interested parties to express their views on a proposed bill in organized manner. So advanced registration here is required to attend the public hearing. And just yesterday, we have the public hearing for the position of Commissioner of Human Rights. So it's very, very used tool, especially in this term of Polish Parliament. Only on local level, we have the participatory budgeting, which is quite famous in Poland. Involves, of course, the allocation of some part of public funds to select project proposed by the residents. This tool, as I said, has been in use in Poland since 2011. However, the regulation of this participatory budgeting was in introduced in 2018. In practice, many cities in Poland organize these participatory budgetings and allocate between 1 to 3% of their annual budget. Then, what is very important, participatory budgeting is mandatory for the big city with the county level status. So, in such case, the cities must amount to 0.5% of the annual budget. But in practice, they are very often allocate more. Unfortunately, the voter turnout for participatory budgeting project is not so high, around, in general, of course, around 18% of city residents. The last, maybe not such popular tool, but really interesting from the participatory perspective is the local initiative, not to the lawmaking, but to the project implement. It is a form of cooperation between residents and the local authority, which enables joint implementation of the public projects for the benefit of the local community. Residents put on the table their ideas and contribution, like voluntary work or some materials, while the local authority provides the remaining funds. So it's very nice practice, you know, to show some of your ideas and to invite the local community, local authorities to implement this project. We also have 10 years of experience of citizens assemblies, which are very common deliberative tool, but unfortunately the citizen assemblies in Poland are not regulated in the law. So most of them are provided by on the provision of the public consultation, like such specific form of public consultation, which is sometimes could be dangerous for the participants. I need to go next slide. So another important participatory law in Poland is the Act on public benefit activities and volunteering from 2003. This public provides firstly the principles of cooperation between the public authorities and non-governmental organizations, NGOs. Also provides a legal definition of this NGO. What is very important, this act provides the possibility for NGOs to receive 1.5% of income tax in specific criteria are met by the organizations, and also provides some advisory councils like Public Benefit Activity Council, who is obliged to provide the feedback to governments about this third sector in Poland. So because I have limited time, I believe I go to conclusions. 1 minute, okay. So 2 slides, 1 minute. When it comes to conclusions, to conclude, the most important, I think, strengths of Polish legal framework for public participation are, first of all, as I said, constitutional protection of fundamental and political political rights and freedoms. Secondly, the legal framework, the institutionalization of mechanisms of direct and participatory democracy, which is still ongoing, if I may say. But we can observe the systematic development of this participatory tools since 1997, when constitutions starts. Also, the very important act about cooperation between public authorities and NGOs. And we observe from our last, I think, 4, maybe 5 years, partial digitalization of participation tools, especially when it comes to the mass participation tools like participatory budgeting, participatory platforms. Of course, comes from the also international experience like the Steam platform or Constiutional platform. And when it comes to the challenges, I think you can find on the slide the most fundamental challenges is the lack of mutual trust between society and the political authorities, because from the legal perspective everything looks fine, but in the real life we have the very problem with the trust between two parties. Sometimes we have the specific procedures for the participatory tools, but we observe that politicians are aware when it comes to the real participation to when it comes also to discussion about public decision. Also, according to what Mirko said, I think that the one challenge is the differences between significant differences between some regions in Poland. For instance, the public participation in big cities like in Warsaw, in Krakow, very well, Also, the cities allocate a lot of money to protect and to provide the participatory tool, while in the small cities there is still a big problem. So unfortunately, to conclude, we need to say that the real scope and the real development of citizen participation depends on political will, not actually the provisions of the law. Thank you very much.
Thank you. We move to our next speaker, Professor Cruzina Tot from Elte University, who is going to present the national report on Hungary. Professor Tot is an assistant professor at Elte University in Budapest at the Center for Theory of Law and Society. She is expert in socio-legal research, legal consciousness, rule of law, and democracy studies. It's interesting because her research focuses on a relationship between law, collective memory, and democratic attitudes, with a particular attention to how historical experiences can shape citizen perception of legality, authority, and the rule of law. And it's interesting, this combination of theoretical inquiry and empirical insights with a view to provide deeper understanding on how law function actually in practice, not only as a system of norms, but also as a lived societal practice. So thank you for being with us today, and the floor is yours. Thank you. Can I stand up? Yes, of course, of course.
Okay, hi everyone, I'm Cruzina Tot from Eötvös University, and I will present the Hungarian constitutional case study here, which I wrote. Thank you. With Zoltán Pozsár Szent Miklósi and Valéria Kis, and I swear to you, I will be brief, because it's hot and everybody after lunch, and because on the other hand, because everything is changing in Hungary. So I have a strong belief that we started this project in one constitutional framework, but we will finish it in another one. So here is the outline, my presentation. First, I briefly talk about the constitution making processes in the recent Hungarian history. Then I also briefly talk about the nowadays social and political changes. Then the strengths and the weaknesses of the participatory system in Hungary. I brought you two examples, which I believe can illustrate our case. And after that, I try to draw some conclusion. So the historical context. I'm sure everyone knows that Hungary has a brief democratic history, 37 years or so. And we have a record because there will be the third constitutional making process starts in September. So we had a previous constitution initiated in 1990. Then the Orbán government shifted it, changed it. They initiated their own constitutional constitution, and as a result, their own participative framework. And now the TISA government won the election with 2/3 majority, with constitutional opportunity again, and we are in the middle of the transition. So as the Fidesz government, the Orbán government had their own constitutional system. In the election with high record turnout, the TISA party promised several times, and they announced after they initiated as a government that they will change the constitutions, that we will have another constitution, and they have some promises that will be a highly participatory constitutional making procedure, which means not just involving the NGOs, the experts, the academic era, but the whole Hungarian society as well. So what's the strength? When we got this question from Angela, that was the hardest part, I believe, but we found some. So in technical surface on paper, we have a rich toolkit of participatory, any other national constitutional framework. We understand the public hearings, social and public consultation, right of petition, local and national referendum, of course. And the technical execution of referendums and elections is sufficient. That was sufficient. So we believe the election wasn't cheated, the result was right, but that, as I said, just the surface. And also for example, the right of assembly, on the practical execution of that on the administrative field and on the side of the police was also sufficient, was also okay. We had bigger success to find the weaknesses in this system. And I talk about the current constitutional system, so the urban government system, not that's kind of changing what's happening in Hungary. So these opportunities, these participatory opportunities were highly manipulated by the government. So for example, we had referendums in the past 16 years, but just the urban government was able to start a referendum, so not anyone else. And we also had national consultation. I will come back to this point later on in my presentation, which was also highly manipulated as well. The previous regime restricted some rights, some constitutional rights, like the right to strike or the local level referendum as well, so that those were restricted. The right to the assembly was untouched until 2025, but then they restricted that as well on legislative level. The urban government also stigmatized the civil society, the NGOs, the free thinkers, the media, and so on, everyone who was not loyal to the urban government. In the case of minorities, they had no representation, or they were underrepresented in the previous parliament. For example, in the previous parliaments, the women rate was 10%, which is way above the EU average. And also, so the root of that was the top-heavy electoral system. So in the last 5 elections, the winning party won the 2/3, which a constitutional making majority in the Hungarian political system. So they were able to change everything how they wanted to. And the 2 examples, the first is about, I'd like to show you how the previous system worked. This national consultation, the national consultation on formal level, that was a highly participated form. That was an invention of the urban government. Every citizen got this form via mail, so in a correspondence, and it was a direct correspondence between the government and the Hungarian citizens. But that's just the formal level. If you see, this was the first national consultation. So the title of this national consultation about migration and terrorism. So they linked together the migration and the terrorism. And that's how they manipulated the system. And I translated one question from that. That was 16 questions. Do you agree with the Hungarian government that instead of immigration, support should be directed toward Hungarian families and children yet to be born? So somehow the unborn Hungarian children was the enemy, or vice versa, the enemy of refugees. So that kind of question, the national consultation contained that kind of question. And we also didn't know anything about the data. So we didn't know how many people sent it back, how many was invalid, and we see some percentages, but what does that mean? We don't know. So that was on a formal level. It's a participatory form, but above that, on the substantive level, it was definitely not. And I brought you a second example. It shows not how the Orban governments worked, but how it is changing nowadays. And I also like to show you some positive examples of the Hungarians. So in 2025, in that time, the TISA party, the opposition at the time, became more stronger and stronger. And the Fidesz realized they can beat them. So the Orban used the old recipe and find a new enemy group of him. And that enemy was the LGBTQ people, who he referred as a whole group as pedophile. And because of that, he said the pride couldn't have happened. And in the next month, they altered the Act of Assembly. So they didn't alter the constitution itself, but they altered the Act of Assembly. And that's why the police prohibited, they banned the pride. But on the other line, the mayor of Budapest, who was the opposition of Fidesz, opposition of Orban, and the organizers of the Pride announced that they will organize a private event, so not under the Act of Assembly, but a private event which called Budapest Pride. So that's how it was a really interesting battle between two forces. So the official communication of the police and the official communication of the government said the pride is banned, it's pride, and the police said it will dissolve by force if it's necessary. And on the day of the pride, we didn't know what would happen. But the result was that was the biggest demonstration in Hungary in the modern history. Approximately 300,000 participants went there, and okay, it's debatable. It was unlawful or lawful event, but that was really significant, and it was the first sign that the TISA party can beat the Orban government. And even though the official police communication was that they will dissolve the assembly, they didn't. Actually, they did really professional work and provide the demonstration. So what the conclusion is in the previous system. On the formal and technical level, the Hungarian system functioned well, at least on the formal level, and it possessed rich toolkit on paper, but on substantive level, the substantive level, the participatory opportunities were weak, and if it happened, that was highly manipulated. And the current constitutional making moment hasn't started. It will start in September, according to the official communication. And it includes both an opportunity and an uncertainty, because we don't know how that will happen. I believe the member of the government don't know how that will happen, but this is the situation in Hungary, and thank you for your attention.